Good morning, everyone, and sorry for the delay in getting started. We do have a lot to talk about, so we'll just get going. My name is Shana Horton. I serve as the rules attorney for the TABC. With me is Matthew Cherry, and Ashley Johns is also here to talk about Chapter 50. It is August the 12th, 2022. This is a stakeholder meeting regarding potential amendments to Chapters 45, 31, and 50 of the Commission's rules. And without further ado, we will start with item 1, which are some proposed changes to the cash credit portion of Chapter 45. I want to preface this by saying we realize that these are a departure from what we've been doing in the past. The reason for these proposals or for these ideas that we're pitching to y'all today is that the Sunset Commission, there was a management action item to reduce the number of warnings for non-payment or delinquent payment on cash and credit. So to that end, we've been actually working on this and kicking around ideas for a while. And we just got to the point where we thought, okay, these ideas are ready for some feedback. I think it's highly likely that we will need a second draft and that we will need a second stakeholder meeting on that draft before we go to the commission for proposal. So there's no need to be panicked or anything about this moving too quickly. And we are just here to really to solicit your feedback. We just kind of wanted to put this out there, see how you think it might impact you, see if you think it might work. And if not, why not? So again, just kind of putting some things out there for your comment. So without further ado, we will get started on Chapter 45. Again, okay, so there's a couple of major things that this does. Obviously, it reduces the number of warnings that don't result in a violation from 6 to 3 for credit law. That's just to comply with that management action. Other than that, we've decided that we should add a definition for a cascading event so that if there's one account that goes bad that results in several other violations, we can consider that a single violation. A delinquent, no one's on the delinquent list if they pay their account within 4 days of the due date, and a mailed payment is not late if it is received within 4 days of the due date. Otherwise, a payment is late the day after the date is due. And that the 4-day grace period we're clarifying is not simply an extra 4 days. The payment is due on the day it is due. And if it's not paid, it's late. The 4 days is your time period to correct that default so that you don't get placed on the delinquent list. So that's a lot of the changes in here are to make that clarification. Let's start with credit, just the credit law portion. Oh, again, and then toward the end here, with AIMS, we are going to have the ability to update the delinquent list. So we often have accounts we find out after the publication date that they were actually delinquent because there's a check returned or something returned for insufficient funds. So we've added in here the possibility of updating the delinquent list if we find out after it is published that someone was in fact delinquent due to insufficient funds. Anything you want to add to that right now?
I think that covers it.
Okay, so yes.
Marcus Schwartz.
Oh, okay, Marcus, you're up.
Unmuting myself. Can you hear me?
Yes.
Okay, excellent. Marcus Schwartz, Bracken Schwartz. Thank you all for doing this. While we're doing this, and I note this is kind of just a general thing, but I will tell you, it's caused some confusion out there when we're counting these 4 days. And I know it says when payment is due under 102.32C. which the reason I'm bringing this up is I've been told that sometimes invoices are sent before the time of delivery, and then there's a subsequent invoice that comes along with the delivery. And so I've had questions and confusions about, okay, when does the time actually start? And my thought is it would be upon delivery, but maybe that's
Right.
something that's worth clarifying in here just to avoid
Right.
confusion.
So we added that, that we're going to consider something delivered when it's actually delivered, and that we've also added a requirement that the invoice be signed or otherwise acknowledged if it's an electronic acknowledgement on that same day. And so if for some reason that is unworkable, I need to know that, but that's how we were proposing to sort of, to square all of that together is you have to do some sort of signature acknowledgement of some kind on the date of receipt.
Understood. And I think that makes perfect sense. Thank you.
Lance.
Good morning, Shana. I had a quick question on the 6 to 3 warnings and the management action. Is that a recommendation or is it a hard, fast, you got to go from 6 down to 3?
Oh, no, it was a recommendation to reduce the number and to essentially there's some folks who are essentially using up all 6 at every location they have, and it's kind of resulted in a way for people to play a bit of a shell game the system, and end up with basically a 2-week grace period or credit line. And that is not the intention. That's not how it's supposed to work. And so the management action was a recommendation that we consider reducing the number of warnings to address that situation.
Okay, yeah, I get that, and I'm obviously for those bad actors out there, I would recommend or at least explore a way to try to capture that subset of companies to do that. I think going from 6 to 3 is going to hurt the smaller retailers more than it will any larger retailers, because the larger companies have access to capital that a lot of smaller folks don't. So my concern is that from going 6 to 3, that's gonna hurt the smaller folks. And my friends in the wine and spirits industry are gonna laugh because they've heard me say this for the last 15 years. The delinquent list is the punishment. If you can't buy product, that's why you're on the list. And if that's not punishment enough, I don't know what is. But certainly I know, and I understand your point about gaming the system. I'd like to try to explore a way to try to capture that, particularly in an inflationary period that we're in right now. And we're all having trouble finding employees, and supply chain issues are real. I mean, this is, adding one more thing to their plate is could be problematic. So I thank you for the discussion, and I look forward to working with you.
Thank you. And I would love to hear your ideas on how to narrow the impact so that we're taking care of what the real problem is. And we certainly don't want to make something that's unworkable for smaller folks. I would like to point out that as we go forward on this, the earliest it would be in effect would be next April, I believe. So we do have some time, and this wouldn't be something that anybody would be dealing with till at least next April. So
cool. Thank you.
Let's talk. Tell me how we can do that, how we can tighten it up so it's not impacting people that are just doing the best they can with what they've got.
Well, will do. Thank you.
All right. Edgar.
Thank you, Shana. I have several comments. First of all is the 4-day period, and this affects sections B3, BI, D1, and D5. Under the statute 10232C, it talks about 4 business days as opposed to calendar days, and there seems to be a disconnect between the rule as written as opposed to what is in the statute. I also echo Lance's concerns about reduction of the number of violations. The goal, of course, is you want to have bad actors weeded out, but I think there needs to be some more discussion about that. Our concern with this is more on the lines that individual outlets now lose the ability to seek shelter in the warning system. So instead of being, say, 3 per outlet, it's 3 for the entire chain. And really the problem is if you have businesses that have multiple outlets, you may have independent payment systems, independent bookkeeping and whatnot. And we think that this has an effect where they can be unfairly punished when there really isn't any wrongdoing. It's just a sort of a accident or some other unforeseen circumstance happens. So we'd ask the commission to look at that a little bit closer, whether this is the right decision, because it does then put the chains in unequal footing in compared to some of the small businesses. We do also have concerns about 45-130 D6. We realize this is an existing rule, but it is a bit problematic in the sense that it allows essentially an uncollectible or unenforceable debt be bestowed upon people that are not connected to an existing permit. So here's where we see it. First of all, under 102.32 D1, and this is where the rule comes from, the purpose is to prevent a retail debtor from being controlled by the distributor. This means that the definition of person is limited to natural person or legal entity in the context of the statute. A debtor is the natural person or entity that is liable for obligation under common law and contract law. The business organizations extends that principle and shields officers, directors, managers, limited partners, and the like on those same principles. And furthermore, a natural person or legal entity is the only one who holds the permit. Agents, servants, and employees do not. So if you're applying this rule towards, let's say a CFO is tied to a delinquent account because he's working for company A and now he has his own business, it doesn't really make any sense to go and ding him for purposes of credit law. Because again, it perverts the purpose and intent of credit law by giving a distributor the right to enforce a debt against someone who's not in privity between the creditor and debtor. And not only does it run contrary to credit law statute, but there's really no common law or statutory law that supports this. And then second, it just lacks common sense. It's kind of like flipping agency principles upside down. So Shana, if the agency owned, say, several $1 million in liability, you can't renew your driver's license or your law license until the agency pays their arrears. And the logic here is that, well, you work for the agency, so as an agent of the agency, you're responsible for the principal's debt. So that's really our concern there. We've written some comments about that, how we think it can be fixed. And folks that are listening are welcome to read that on our blog at griffithhughes.com. We also have concerns about 45-130 E1. This is the delinquency list. We think that there should be some discussion whether the delinquency list is revised, because right now you're guilty until you're proven innocent. And our understanding is that there really isn't any vetting. It's just as simple as somebody making a complaint, puts in a check number, invoice number, and we really don't know whether those delinquencies are related to liquor and not something else like, say, malt beverages. Finally, we do have concerns that the rules as written don't seem to take into account bankruptcy considerations. Placing somebody on the delinquent list, if there is an automatic stay, appears to be an other action which is prohibited under the bankruptcy code. And also if somebody is discharged, either pursuant to an order of discharge or confirmation plan, it also has that effect of appearing to violate the bankruptcy code. And so we'd ask the commission to take that into consideration and modernize this rule so that those are in parity with other existing law. Thank you.
Thank you, Edgar. And just to make sure, everything that you've mentioned here today is part of your written comments, correct?
That is, yes.
Because I'm definitely going to need to spend some time with I'm not a bankruptcy expert, so we're going to need to spend some time offline with that information. So thank you.
Thank you.
I would say too, though. Specifically just on the bankruptcy portion, as a practice historically, and I believe this, I know at least it used to be up there kind of as a note on that delinquent list. We have not enforced the delinquent list against someone who is actually proven up and given documents over to the agency that they are in bankruptcy. But we will definitely discuss to see if that is something that we need to make more clear and actually put it in the rule to formalize that.
Thanks, Matthew. Okay, next is Kelsey, Texas Restaurant Association.
Good morning. Don't want to beat a dead horse, but we have some of the same concerns that Lance and Edgar raised, especially changing the number and combining, aggregating violations for businesses with multiple locations. I think that might be the biggest red flag for me, just thinking about some of our operators who have, dozens or 100 locations across the state. That's a pretty big change. So totally understand, Shana, your point earlier. Would love to work with y'all, on how we can address that concern without having those unintended consequences.
And I'll say the same thing that I said to Lance. We're open to your ideas, how to narrow it down to, to the bad actors, to the people who are abusing the system without, causing problems for people who just have multiple outlets and maybe have different bookkeeping systems and that sort of thing. So let's get together on that.
Absolutely. Thank you.
Okay. Next up, Amy Harrison.
Greetings and thank you. Some of what I'm going to discuss is just an overview and has been mentioned, but reporting a violation, when the seller's going to report the violation, it would appear to me that they do what appears to be a very simplistic report in which a retailer immediately sees punitive action. Like Lance said, just being on the list is punitive. And then when the retailer goes to show that they should not be on the list, the amount of evidence that they have to produce is not level to what the seller had to give to show that they deserve punitive action. So it just seems to me that that's a little bit unfair. And I would also ask that when the retailer goes to determine, to defend themselves, there doesn't seem to be a lot of historical data available to them to determine how many times should they or should they not have been on the list, primarily because the seller seems to be putting in very little data. And then my other question is that when the seller does give this information and as the agency works the delinquent list, is there a way to statistically determine that, hey, man, the problem's not with the retailers, the problem's with this seller. This seller continues to report people that then have to spend time with the agency defending themselves, when in reality, the seller is reporting inaccuracies. And maybe the seller needs to have a lesson in books and records review and how to utilize the system. The only other thing that I would say is I think we all here appreciate the fact that you're here primarily because of Sunset's recommendation. But, the reduction from 6 to 3, can you tell us statistically how many locations you would be looking at and what would be the impact to your resources when you reduce these from 6 to 3? Because we all know that you're suffering with lack of resources. And so what kind of impact is this going to actually have on the agency? Last but not least, I appreciate I recently had a package store who got their LP, and an auditor, Donna Torres, went out and visited with them and gave them an incredible training and really went over their books and records. And I just want to commend her and the agency for going out there and addressing this and really helping small businesses be compliant with it. She did an incredible job, and I just want to take note to that. That's all I have. Thanks.
Thank you for passing along that compliment. That's awesome. As far as what kind of impact going from 6 to 3 will have on the agency, of course, we thought about that when we were thinking about the different numbers that we could choose. That's why we didn't go with 1 or 2. But we don't have a statistical analysis of that. What we have is the folks that work in our audit division, and we have also some new technology that should streamline things a little bit. But there is a possibility that it could prove to be, that could prove out to be more violations than we want or intended. So that's just our kind of our best guess based on people's their experience and on kind of what the ways we're going to be able to speed up and streamline with the new technology that might help a little bit. But your point is well taken, and we don't really have a way of proving that it's going to be exactly the right fit. So that's going to be something that we'll probably have to work out in practice, and if it's not working, make an adjustment. Okay. Other comments on the credit law changes, 45.130. Looks like Bill DeFore, you're unmuted. Are you?
Yes, ma'am. Did I unmute? Oh, I got it. Can you hear me?
Yes, sir.
Good. Okay. I'm going to ask the question bluntly. I don't think it's been asked, but so I have a retailer that has 100 locations, and they have 3 violations at 3 late. Let's say they get over 3 at 3 different places. Does that mean you pop all 100, or how does that work? Or is it the location that's the problem? And I'm looking at, 130 D3. I mean, a retailer is subject to administrative action, including penalties at any of its retail locations. So do you count the 3 as being at 3 separate locations?
No.
Okay.
So if there are 3 at 3 separate locations, that's 3 for that entity. So that's the next violation will be 1 violation for the whole.
For the whole. So okay. So the issue about each permit stands on its own doesn't count here, because each permit has to, if you've got one that's 3 that are a problem out of 100, that means that 4th one pops you into the violation. That's what you're saying.
Yes.
Okay. All right. I just want to make sure that's what that was. In the old days, each permit kind of stood on its own as far as if you had 1 violation here, 1 violation there, that was it. So anyway, that's just my comment. I appreciate it. Thank you. Thanks for what you're doing, Shana.
Thanks, Bill.
I'll add one thing. I will say, kind of on this topic, one of the things that is also looked at, and I'd like to maybe remind people of, especially the attorneys, and take a look at it because it might be helpful to us with your feedback. And it's 11.66 in the code, which talks about how penalties are supposed to be assessed per, I guess, each kind of individual location for all kinds of violations in the code. But it does have an exception and says that standard doesn't apply if it's going to be a violation of the cash and credit law. So that does come into play with this, but it's something that we'll definitely look at some more.
Thank you, guys.
Okay, I see Amy's hand up again. Amy?
In relation to Bill's comments, I'm just curious with Ames and this implementation, if a violation was assessed to Amy's Burgers, who had 20 locations, how is that violation going to be attached? Is it going to go to all 20 permit numbers of Amy's Burgers? Or how is that history going to be captured? And is it going to be somewhere else? Because most of us look at violations by location, by permit number. So in Ames, how do you foresee this documentation taking place if it's against the entity?
I know we talked about this in a meeting, but it could have been over a year ago. That's a good question. I'll get with the people who are more familiar with Ames than I am about how that might be accomplished. I just can't recall right now I know we discussed it, but I can't recall exactly how that's going to be done, but I'll get back with you on that.
Thank you.
Dewey.
Hi, I was just making the same comment. I mean, I understand what Matthew's saying about the statutory authority there in 1166. I don't know, in the real world, workable wise, how you can say if you have, 1,000 locations. I mean, you have permittees with 1,000 locations. And so if they have, 4 out of 1,000 violations in the big scheme of things is pretty de minimis, in my opinion. But if, I see if they roll up on a location per location, but I just think it's going to be very unworkable, not only for you guys, but for the clients if we start aggregating all those and kind of, to Amy and Bill's point, have some kind of overall, your entity has X many violations, right? What are you going to put it on the master file? Are you going to put it on the individual stores and then aggregate them? Anyway, I don't want to belabor the point because I know it's already been made, but I could see when you're talking big chains with multiple locations and there's at least 20 entities that I can think of that fit that bill, if not more. That's going to be very problematic for everybody to manage. So please, yeah, if it's the Ames folks or whoever, I just think that's going to be difficult to make it a workable system.
And if y'all could help me understand and just provide me maybe by email or a phone call later, just with your particular constituents and clients, if you could provide me with some detail about what you mean when you say it's not going to be workable for them, or what kinds of, just a little more specificity would help me understand where the rub is. So I would appreciate that. Anyone else on 45-130? It's been 30 minutes and we do have a lot to get through. So I'm going to go ahead and move on to 131, which is the cash law rule. Scooch down to that screen. Again, we've updated the definitions to include a cascading event. We know that happens more often in the cash law world, where one incident that drains an account can result in multiple incidents occurring, and we would want to make sure we count that as one. The difference here in cash law is that we are actually required, the rule is drafted so that we would be required to count a cascading event as one, rather than it being a discretionary thing. So that's, to acknowledge that happens with more regularity in the cash law environment. But the big thing here, I think, is the idea of somehow trying to make cash law, the system, a little bit more like the credit law system, without disadvantaging those who are working under cash law due to the differences. So we thought of, if we were to count violations just twice a month, and then, but the violations still occur when they occur, but we would only go and look at it to see if a violation has occurred twice per month. Then if you had a cash law violation in that period, that would be one violation. What do y'all think of that? Oh, wow. Must have been a great idea. Amy.
I certainly appreciate trying to be consistent among the two. But again, my question is statistically, what are you looking at? What is the rest of us looking at? If you, based on your numbers today, if you changed and redid your numbers based on the rule, what does that look like? Because we don't have those statistics out here. But it's a concern because, you know, your resources, our resources, and other things that might not get the attention that they need. So I'm just curious, what do you think based on the numbers that you have right now?
Is there any subject matter expert on the line who would like to comment on their assessment of that? Yes, Josh.
Sure. We don't, obviously, we don't have the statistics right now for the audit division, and for the record, Josh Alexander, Director of Audit. We do, what I will say though, is from a process standpoint, as many of you all know, we contact each and every permit holder for cash and credit law at the third incident currently now. That's a current process where we try to go out and educate the businesses at that third, so that, you know, we give them ample warning prior to getting to that, where it currently is the sixth or subsequent, or seventh or subsequent incident that creates, you know, admin action. So currently for us, I mean, we're already contacting those businesses at the third, you know, violation reported, and that's on cash and credit law. So it really is not going to impact our division as much. You know, it just, you know, would be the action that we're taking at that point is going to be different. If that makes sense.
Josh, that's terrific. And thank you very much, because you're contacting them now at the third violation, trying to help them so that they don't get that sixth. Would you foresee that you would now start contacting them at number one?
That would be certainly a consideration, you know, something for us to consider. But that would be a good idea. I mean, I think, you know, we should, as a courtesy, still be reaching out, you know, have some process. And so it would be likely that at that point, you know, we would have to just be making the contact on those first, you know, incidents. And whether we, you know, did that, obviously, as we transition into Ames, you know, maybe looking at some kind of a virtual notification or whatever. And so those are all kind of things that, you know, we'll have to discuss as part of this process for sure.
Yeah, these are just kind of the big ideas right now, and details like that are something that we would have to look at should we decide to move forward with a plan like this. But yeah, when we were talking about it, you know, Josh was obviously a big part of our discussions, and he, you know, expressed that he thinks that this would be a good balance for his team based on their workload right now and the resources they have. And again, like if it didn't turn out that way, you know, rules are not written in stone. So, and the other thing I wanted to mention was, if we do move forward with something like this, there would be a significant education and outreach and communication component, obviously, because this is a change to the way people have been operating. Some people operate under the assumption that they're going to have 6 violations, which is part of the problem. So we would definitely have to have a concerted effort to get the word out and to educate people about how the changes impact them.
Josh, your team's doing an incredible job, and my concern is resources on your part so that the rest of the agency can do what they need to do. So thank you. And again, if you didn't hear my comments about Donna, she's rocking and rolling. So thank you.
Yes, ma'am. Thanks, Amy. I've made note of it, and we certainly appreciate your feedback.
All right, those of you who represent cash law retailers, any other thoughts or concerns, or just, again, that we're at the big picture stage, so it doesn't have to be something specific. It just, you think it's a good idea or a bad idea. Just general impressions are what we're looking for. I'm not seeing any hands. Okay, well, if you take a look at it and come to a conclusion later about whether it's a good idea or a bad idea and why, you know where to find me. Rules at tabc.texas.gov or shana.horton@tabc.texas.gov. With that, unless there are any other hands that are raised, we will move on to item number 2 on our agenda. Okay, excellent. Item number 2 on our agenda is the 4-year review of Chapter 31. We have some rules in Chapter 31, obviously, as you know, we have addressed within the last 4 years, but some we had not, and so we needed to do the comprehensive 4-year review of the chapter. And what you'll see is we've basically made very, very few recommendations. The main recommendation that we're making is to address the complaints process, which will be a little bit different due to technology changes. And when looking at the current rules, 31, 10, and 11, were needlessly complicated. So we decided to just start from scratch on that. So we're placing 3110 and 3111 with a new rule. It's labeled 31.xx right now, just because I'm not sure where we're going to want to fit it in. And it does, what the statute requires. So it's says that we're going to, the different ways that you can file a complaint. We're trying to, we have to have a balance between having ways for everyone to have access to that. But we also need to not have complaints coming in all over the place by all different means, to the extent that that things fall through the cracks. So we're trying to balance that with having, the complaint form by mail, calling a certain telephone number, through the Ames public facing website, which does not require you to have a license or permit to file there, or by email. And then we also provide it's going to be the same complaints form that y'all are used to. And we also provided outline of our complaint process. Obviously every complaint is different and might require a different way of handling it. And so we necessarily couldn't be like super detailed, but we can tell you what the steps are. And also we have added in here that the person who is managing the complaint will contact the complainant to inform them that the complaint has been received. And they will again contact them to let them know what the final disposition was of the complaint. So in other words, was it closed, rejected, or resolved? So those things weren't in the prior rule, but we want to make sure that anyone who provides their contact information and says they want to know about those things does. Of course, as y'all are probably aware, most of our complaints that we receive against licensed and permitted businesses are anonymous. So I will open the floor to your questions and comments about this completely new complaint rule. Marcus.
Yes, Marcus Schwartz, Bracken Schwartz. Our 31XX complaints, I have issues with B, where the commission shall not release information related to a complaint if doing so would jeopardize ongoing undercover activities. I assume this is addressed at open records type deals, and you already have protections under the Open Records Act not to do that. So I don't see the need for this. The other thing is, or two other things I'd point out here. One, ongoing undercover activities. It's not written to be just for the commission. So for instance, if a complaint gets forwarded to local law enforcement, I don't know how much the commission would know about that local law enforcement investigation or when that would ever end. So potentially you're never getting that thing. And the other thing I would point out is, you know, say the complaint is a public safety violation and there's a citation that gets issued. Regardless of whether that citation actually sticks and ends up being a violation or not, that person's on a priority list. So there's going to be ongoing undercover operations for at least a year and a half. And so could that person then not be able to get that complaint for a year and a half?
We have someone on the line. Yes, Victor, would you like to respond to that and state your name?
Victor Kirkendall, with enforcement, Director of Rural Enforcement. So as far as a closed complaint goes or a closed investigation, obviously if we're serving a notice to the permit holder or their staff, that's going to be something that's resolved and can be disclosed. Our concern here is just not disclosing anything that put at risk of anything sensitive of an undercover nature that's not closed. If we forward an investigation or the complaint to an outside entity and we're no longer a part of it, we'll let the complainant know if they leave our information that we have forwarded the complaint and have closed it out on our side. However, if we forward it or are part of it as part of like maybe a federal task force or something along those lines, it's still going to be considered open on our side. So while that's going on, we will not disclose those investigations. But once we start serving notices, because we typically don't serve those notices until we're finished. Once we start serving notices, they should have ability to look and see what those violations are. I hope that answers your question.
I get that. Just one of my concerns is not necessarily on the complainant side. It's against the potential violator, right? That they, again, just depending upon the interpretations of this rule, potentially, even if there's no violation found, but I mean, you know, there could be a citation. There's a way this rule is read to have them not be able to even figure out why was I complained against, who complained against me, you know, is this a competitor complaint, which does happen for a lengthy period of time. So
right, if there's no violation found, that closes the investigation. It becomes a matter of record. Of course, there are certain protections obviously out there, and you pointed that out, but for the most part those protections are there. And once it's closed out, it's something that can be divulged. And if a complainant wishes to be notified, we'll let them know. But obviously, the permit holder, unless it's something sensitive like trafficking or organized crime or something like that, that disclosing the disposition may jeopardize future investigations, we may have to consider those things. But
I get that. I think you're already covered by existing law. It's just the one thing that I'd note.
Okay, we'll look at it.
Thank you.
Yeah, and I was going to say, Marcus, you know, maybe we will be a better way to do it would be possibly by with some reference to the PIA. The reason we put it in this rule is because it's something that comes up a lot, that people want information that it can't be disclosed at the time. And this was sort of a, you know, acknowledgement here just to kind of make sure everybody's on notice, like this is why might have your request declined, just because it does come up with regularity. But it might be better to add in some cross-referencing there. So thank you for pointing that out.
Thank you.
And thank you, Victor. Edgar.
Thank you, Shana. I'm echoing some of Marcus's concerns about complaints from competitors. We've run into that kind of thing from our perspective. The other is there seems to be a transparency concern in many professionally licensed regulated industries. When a complaint is made, the target is made aware of that complaint and is told what's going on, where it is in the stage, and so forth. Now, I understand there may be situations where it's not appropriate to notify the target because it will jeopardize the investigation. But for things that are not undercover related, I think the rule needs to incorporate, or at least should incorporate, things such as notification to the permit holder, communication when the complaint is expected to be resolved, and also what the resolution is. And it also serves another function. Even if a permit holder hasn't violated the law or hasn't been shown to violate the law, when they're apprised of a concern, this gives them notice and opportunity to go and talk with their staff, their management and whatnot, say, hey, we're getting complaints from the, PD, or we're getting complaints from local neighbors. Let's revisit what our policies are like. Can we run our operations a little bit better? Even though we haven't violated the code, we want to be a good partner, a good neighbor, and a good permittee. That's all. Thank you.
I'm going to throw that one back to you, Victor. Do you have any response to
No, I
that?
mean,
How do we notify those folks?
yes, can you hear me?
Yes.
Okay, so Victor Kirkendall again. Yeah, traditionally, most of your common complaints like seldom minor, seldom talks, things of that nature, yes, we're going to be communicating those things because we want to try to drive more a compliance-driven method. We want them to kind of help self-regulate, educate, and so it kind of reduces our tasks to resources that we're having to apply. But obviously, just like you point out, there's going to be certain circumstances that we're not wanting to make them aware of our investigation because of the nature of the allegations. So I don't know that I want to memorialize it into a rule. We do have a process and procedures inside, and quite frankly, I'll be honest with you that we're getting a lot of counter intelligence or surveillance done against some of our folks, and they're trying to vet out some of these processes, trying to see if we're actually conducting some of these investigations that are sensitive. And so they're doing open records checks and stuff like that. And we just don't want to put out there, hey, we can't disclose anything because we got an ongoing investigation on you. Well, that tells them something that they already know. Now that just confirms it. So we got to be very careful not to put our staff and others in jeopardy when it's involving some type of investigation like that. However, those are the exception. Majority of the stuff we do is your typical type of investigations like seldom minor, things like that. We do want to let them know, and we should.
And so there's nothing in this new rule that would change the way that you are currently handling that difference between things that you don't, your internal process for deciding what is able to be released and what would endanger an operation.
It just allows us flexibility, making discretions of what would be sensitive to be released and what's not. But we should be communicating on those typical violations with the permit holder so they can turn around and take steps to prevent those violations from occurring in the future. Typically, something we do an investigation, we do an open inspection saying, hey, we got a complaint about X, and then we tell them, so we may be in here to look at you undercover otherwise. And then after the resolution of the complaint, we let the permit holder know what the disposition was, and we encourage them to continue doing their efforts to monitor these things themselves so they don't have those issues moving forward.
I'm making some notes real quick, just a second. Okay, so what I'm hearing, and this is something we talked about when I was drafting this rule, is that there is some difficulty in putting very detailed information about how those decisions are made into a rule because every situation is different, and so much cannot be revealed about those few exceptional investigations. And so that is a tension that we're having to deal with. And I understand that leads to uncertainty, but the fact of the matter is that's actually always been there, and it hasn't been an issue because when there is a complaint about sale to intox, sale to minor, there is communication. So the fact that it's not written into a rule that way, which could potentially bind the agency in an unforeseeable situation, has not heretofore been a problem, and I wouldn't expect that it would be in the future. So thank you for being here to explain all of that, Victor. Amy Harrison.
Well, with all due respect, I don't think I would say there's not been a problem. Maybe you just don't know specifically of all the problems, but transparency, just to echo those before me, transparency seems to be a concern. And we're painting complaints with this big broad brush, regardless of whether it's a criminal complaint or an administrative complaint, regardless of whether it's a complaint related to public health and safety, as opposed to another kind of complaint. So perhaps if we divide out those types of complaints and how those might occur and be treated, that would be helpful. When you look at, a long time ago, the commission published its guidelines and procedures for working complaints. And so you knew that there was a time frame around that, and that people within the agency were having to take action concerning a complaint within a specific amount of a time frame. And at least you knew with some sense of comfort that people were actually working the complaint to get to some type of resolution. I noticed that in the LAR, the commission's asking for additional enforcement agents, probably due to the need of complaints received. And so my question would be, statistically speaking, how many complaints are you getting that are anonymous that then turn out to not turn into a violation? And it really is just a competitor harassing another competitor, and they're utilizing the regulatory agency to do that for them. I have long, and anybody that knows me, have issues with an anonymous complaint. If you're going to complain, you ought to be able to put your name on it. And I understand criminal complaints, why that you can make it obviously a very good reason for not requiring a signature. But administrative complaints, if people want to complain and it's an administrative complaint that is not about public health and safety, I'm not sure why the commission's not requiring people to sign those complaints, thereby reducing, I would assume, the number that are not legitimate complaints, thereby reducing the number of resources that are required on the agency's part to just go out there and do, work that's not got a legitimate concern surrounded around it. Can you tell us statistically how many complaints the agency receives that are anonymous as opposed to not anonymous? And with that, can you tell us how many of those complaints actually result in some type of action on the part of the commission that is a penalty or warning or something?
So I don't have the numbers in front of me as far as stats go to how many were anonymous versus not, though, as we already kind of stated, a lot of them are anonymous. I can tell you that we looked at, because we're having to, as you astutely point out, that we're having a big issue based on the number of agents and staff that we have available, the number of complaints that we're receiving, and the resources we can apply to those complaints, addressing those. So we're having to triage our complaints. Some of the challenges is that even when you have a complaint that we know somebody's a problematic location, we have history for that location, even the complainant is divulging who they are, versus these first-time complaints, anonymous sources, things of that nature, where you could probably be a little bit more dismissive. We looked at it and we're seeing it's roughly about the same likelihood of finding a violation, for at least public safety violation, at those locations. And unfortunately, not all of them are coming from competitors. some of these are actually employees that are seeing their peers doing things that shouldn't be correct, or their employer doing things that they shouldn't be doing, and they're fearful for their employment. They need the job, but they want to make us aware of what's going on. And so that's the only information I can provide right now, but I'd be glad to turn around and look and see how much anonymous versus non-anonymous complaints we receive.
So Victor, out of the non-anonymous that you're receiving, are those primarily coming from employees? Are they coming from someone else that's permitted in the industry? Are those that are not, go ahead.
No, just because of the source, we don't know, but some of them are telephone calls. I can tell you that they come from all variances, but I couldn't tell you with a certainty of how many are coming from other industry members, how many are coming from employees. But just because they are anonymous, we can't track that information.
So what about the ones that someone does sign? Do you have any feel for who those people are? The ones are there categories of people who routinely?
We don't have it categorized when they turn around the source of the deal. I mean, we try to when we receive them, but that's usually what telephone or whatever, if they disclose who they're with. But a lot of times all we get is a name and a contact information. And we don't really track the source of it anymore, unless it's like a government entity, like another police officer saying, hey, I'm getting a lot of DWIs from here. We'll mark it that came from a government source. If we really don't know, typically we just mark it as a citizen. Someone claimed to be a citizen, and then we find out later it's somebody that got, coworker got fired, or who knows what their motivation is. They come from all walks. So.
Thank you.
Perhaps in moving forward, there can be an effort or a methodology for determining statistically what kind of complaints and who they're coming from. Again, I don't appreciate anonymous complaints for administrative violations, because my experience within and out of the agency has been that those complaints are made for a lot of other reasons other than a possible violation of the statute or rules. Thank you.
Thank you.
Other comments and concerns on the draft complaint rule? And as always, if you have some language that you'd like to submit that you think threads this needle that we're trying to thread, I am very interested in that. Please send that to rules@tabc.texas.gov or to me directly. That's always very helpful. Okay.
One last comment, Shane, apologize, but you provided a copy of the form that would perhaps, I don't know if it would be included as part of this rule, but the complaint form. And perhaps, you could go back and look at that form to see if it could help capture some of these statistics that would be helpful, and do an assessment later of what kind of violations you're receiving or complaints you're receiving and from who. So my comments would just lead over to the form and the fact that perhaps it could provide more statistical information, including be available to the individual who they're complaining on. Just my thoughts. Thank you.
Yeah, that's an interesting thought. If there's things that we could document that might help us with triage and deciding where a complaint needs to go in that process. Yeah, and of course, not all complaints come in via the form. So sometimes they're phone calls and emails, and we don't get that level of information. But that's an interesting thought, and we'll definitely explore that. With that, let's go ahead and move to item 3. Do you want to switch places with Ashley? And I know some of you might drop off now. This is this rule. Oh, and I'm sorry, there was one more change on chapter 31. I did add, we've been required to add a rule regarding the family leave pool. For agency employees, I just assumed that none of y'all had any comments on that. But if you do, now's the time. All right. You can always get back with me later if you're concerned about how the family leave tool will be administered within the TABC. So now to our Chapter 50 seller server rule. First of all, I want to apologize for the multiple colors of red lining and purple lining and green lining. When multiple people work on a document, sometimes that happens. So that's all that means, is that a different person made that edit. I have with me Ashley Johns, who is, of course, the keeper of the seller server training program, and knows all things about it. And so what we've done here, kind of the biggest change is that due to getting rid of some of our legacy software, we're going to have to revise the rule so that we have a way of issuing the certificates through a different system. So that's what the main change here. And then we also made some changes based on things that that Ashley has observed that have been problematic over the years. And then some things, gotten rid of some things that were initially considered to be something that people might want in the rule, but as it pans out, no one has taken advantage of them. No one needed it. No one wanted it. And so we're proposing to pare down the rule by removing those things. So with that, we'll start with the definitions. We have added a comprehension question, multimedia component, and personal validation question, and that is based upon Ashley's observations that she's had some questions about what is meant by multimedia component as it's used in these rules. And then that the questions at the end of a section that you're supposed to answer to show that you've actually been paying attention is one kind of question, and then but a personal validation question that's a separate kind of question that's intended to validate that you are the person you say you are and you didn't just get your friend or your sister or whatever to sit there and do it for you. And that those are two different kinds of questions, because there was confusion on that, and some of the personal identification questions were not personal identifiers. We're not effective at that. So we've added some definitions to make sure people understand that needs to be essentially something that they provided as part of their background information when they logged on. Let's see, what's the next big change? We have down in 50.6 removed the section regarding a school seeking approval to offer a course of instruction on a unit basis because no one has taken advantage of that, and it certainly doesn't really make sense in our current online environment. Now we have some more changes regarding comprehension. So you see where I have crossed out and shall not issue a seller server certificate. Anytime you see a change with regard to a seller server certificate, that is to open up the possibilities for how we manage those certificates and manage this program once Versa is gone. We do have Versa for a little while longer, but we don't want to continue to pay for it, especially once we don't have any support for it. So the idea here is to make this change so that we have some options open to us about how to do this going forward without Versa. Okay. In 50.9, we have kind of a placeholder here. Schools have always paid $2 for each seller service certificate number in advance. We are looking at what that number should be based on just inflation and that sort of thing, and then what the costs are going to be if there's a different method of tracking and issuing. But we don't anticipate that will be significant, maybe $3 or $4, but it shouldn't be something that will break the bank. And we are, of course, in a period of transition here at the agency, as you know. That's the kind of decision that we want to come from a policy person, not from me. So that's the explanation for a little bit of delay and kind of coming to a final number on that. But again, I don't think it will be significant to those who are purchasing these certificate numbers. They'll be able to pass that along. And then basically the rest of the changes in here are to, again, allow for the commission or commission vendor to issue these seller server certificates and to take it out of AIMS and put it into a different software setup or online setup. So it won't be through AIMS, but there will be a way of uploading results and spitting out a certificate. And that's what we're working on right now. The need to change the rules before we do that. So that's what these changes do. Let's see. Finally, grounds for refusing to process an application for a school or a trainer. Based upon Ashley's experience, that we needed to expand on that. Final disposition of a felony within 5 years was the only reason before. That's very, very narrow. And it seemed reasonable to expand that to the reasons that we can deny a license or permit application. So this is that same list that you would find there. That's in 50.11 and I think 12 as well. I realize I'm going fast and there's a lot of rules here, but the changes are all pretty limited to just a few categories. Okay, now I skip all the way down to renewal applications, expiration and fees, 50.22. This has been updated to just clarify that if you don't renew and pay your fees for your seller server school certificate within 30 days after expiration, it's just like other licenses and permits. You're going to have to apply for a new one and pay the fee for a new one. And then here you'll see that same list of potential disqualifying factors on the seller server trainer certificate in 50.25. I think, yep, that's going to do it for the major changes. Everything else is basically clerical. Does anyone have any comments or concerns or questions about Chapter 50 as we are proposing to revise it? If you want to add anything, sorry, before okay.
Hey, Shana, this is Kelsey. Just to clarify, so the basic structure of how this works remains the same. TABC certifies the schools run the training, people who pass the training get the certificate. All of that is staying the same, right?
It's just going to be the method of reporting the test results and issuing the certificate that will likely change, Got it. With the new software. It should be easier, more streamlined, require less of the schools. So that's what we're aiming for. But again, we're working on that system right now, trying to figure out the best way to do it. And this is just kind of removing those things that would be an impediment to changing from the schools issuing the certificates themselves.
Got it. And in terms of qualifying as a school, the only thing I'm really seeing that changes is the you mentioned expanding the criminal, and past misdeeds that disqualify you. Anything else on that question of who can be a school, who can be in this space?
No, that was the only, that's the only change. Just seemed like felony conviction was a little bit too tight. So we want to be able to consider other types of problems, just like we can for other licenses and permits.
Okay, thank you for clarifying.
Anyone else on this rule? Mostly impacts, of course, our constituents who are stakeholders who are seller server schools themselves, or those who utilize those schools, so retailers. We didn't change anything on the consumer delivery side. All right, I am not seeing any other hands raised. Okay. Well, thank you all for your time. And again, I apologize for our tardiness this morning. Glad to get out right before lunch though. And I hope you all enjoy the rest of your Friday and your weekend. And as always, you're welcome to contact me, and you're encouraged to contact me by phone or by email to give me your thoughts and ideas, especially about Chapter 45. Very open to suggestions on that one. So it is 11:41 a.m. on August 12th, 2022, and this stakeholder meeting is now closed.